Hello everyone, and welcome back to the Bright Business Owner podcast. I'm Ellis, one of the Senior Employment Law Advisors here at BrightHR. Today I'm talking to Yousaf Mahmood, who is the Head of Employment Law at Irwell Law. Over to you to introduce yourself.
Hi Ellis, thank you for having me on your podcast. Like you said, I'm the Head of Employment Law at Irwell. I started in this position in January 2026. I'm also a qualified solicitor and I've gained extensive experience in employment tribunals, having represented clients day in and day out for the last few years. At Irwell Law, we've launched our new product. It's the Tribunal Edge. The purpose of the product is to provide clients affordable but specialist legal advice services. With the changes coming in with the Employment Rights Act 2025, we are there to give the clients an edge in the tribunal defence.
Very interesting. It's actually the first time hearing about the Tribunal Edge service, but it sounds really exciting, especially with all the changes coming in and all of the preventative and proactive measures that business owners need to implement. So with that in mind, let's talk all things Employment Rights Act. Now, the Employment Rights Bill fatigue is a coined term in the HR world, and if you're in the HR field or the employment law field, I'm sure you are definitely experiencing that. But today we'll be hearing from our business owners as we've got some questions that they would like answers to when it comes to the Employment Rights Act. It's such a huge piece of legislation that affects both business owners and employees, isn't it?
Yes, absolutely. The Employment Rights Act 2025 is a massive piece of legislation. It brings in over 173 new pieces of law, which employers will need to get a grasp to very quickly. It covers everything from statutory sick pay, trade union rights, and even parental leave changes.
At BrightHR, we're getting calls every day from business owners, prospective clients who need support with navigating the Employment Rights Act. So let's see if we can answer a few of the most common questions that have been asked by our business owners to give them some much needed peace of mind. A common position that we're hearing from business owners is, I don't know where to start with the Employment Rights Act, which, who can blame them? There's so many changes, you've got 28 key changes coming in. What's your take on this, and what do you think that, where do you think that business owners need to start with these changes?
Well, the reality is it's a frightful scenario for employers. There's so many new things coming at them. They've already got the fear of being taken to an employment tribunal. On the top of that now, they've got the risk of more scrutiny and more fines in the tribunals. But the best way to deal with it is to tackle it heads on.
Absolutely, and I think you've really hit the nail on the head there, that there's already so much risk for business owners. There's already so much fear in owning a business and having employees. And the government are doubling down on that and making it more difficult to be a business owner. But you need to tackle it head on. You need to install those preventative measures in order to protect your business and the financial detriment of an employment tribunal claim. So another popular topic is, of course, statutory sick pay, a big one coming in very, very soon. But the main consensus is SSP is going to cost me a fortune. What can I do to prevent that?
Statutory sick pay or SSP changes are quite big, especially for smaller employers. The changes are going to be requiring employers to make payments for absences from the first day of sickness rather than having a period of waiting days. The difference on the cost of that is £25 on average per day. So an employer straight away is looking at an additional payment of £75 where an employee is off ill, where previously there was no payment for that period. For smaller employers, these small figures do add up and they do affect the business's income and revenue.
Absolutely, and I think it's a shame for the small businesses that have to, foot the bill on these kind of measures that are being brought in. Gone are the days where businesses can reclaim SSP from the government. It is solely down to that business owner to manage and manage these changes. But there are some measures you can install, from my perspective of speaking to prospective clients who often don't have any policies or documentation in place. You need to have a rigid sickness absence procedure and process in place to prevent that employee exploitation. Employees who are perhaps thinking of skiving work for the day, they can't really be bothered, they're a little bit hungover. Currently you're thinking, I'm not going to be paid for that day off, I could do with the money, so I'm still going to go to work. But now you've got that financial incentive where you could still earn 80% of your daily earnings. So, what's to prevent people from exploiting that? So business owners really need to make sure you've got those procedures in place.
Sickness is always a tricky subject. Like you've said, there are some instances where staff might just want one day off because of a hangover. But then there's also risk to employers where if a member of staff is persistently off and there's some underlying cause, such as a physical or mental impairment, which a tribunal can find to be a disability, then an employer would be expected to take reasonable steps to allow that employee to have some time off but not face disciplinary procedures. So it's really important that the employers have policies in place for it.
Absolutely, and I think that comes down to taking a well-rounded and objective view of every situation and always treating things on a case-by-case basis, never jumping to those conclusions. So another question is, one of my team has asked about paternity leave later in the year. What should I tell him?
So paternity leave now is a day one right, and the changes of parental leave kick in April 2026. So it's really important for employers to make sure that they're updating their policies and procedures and make sure that they are reflective of the rights which are now prescribed by the Employment Right Act. The first thing to do is get your documentation in order, update your parental leave policies, and make sure that the new leave is set out very clearly in the procedures. Make sure staff are informed, and if you've got an employee handbook, get them to sign it.
Absolutely. And if you need advice on topics like this and you're receiving these kind of scenario-based queries or questions from members of staff, why not reach out to the experts and ask us that question, and we can give you that straight answer and make sure that you are navigating these situations in a legally compliant manner, essentially. So a hospitality-based question coming up next. We do have a huge client base in the hospitality industry, and it's one of those industries that's becoming more and more highly regulated by the government. So what's the tipping policy all about?
So the tipping policy is changes to the existing tipping law. You'll already be aware of the trunk processes where tips have to be clearly identified where they go into and how they're being split. But now the Tipping Act can cost employers up to £5,000 per employee if the claim goes to tribunal. And that's even for employees who are not even involved in the employment tribunal claim.
Yeah, it's a difficult time out there for pubs, restaurants, hotels, and hopefully the government puts some provisions in place to assist with legislation like this because, it's a difficult climate. But if we move on to the next question, what about the Fair Work Agency? Obviously, the Fair Work Agencies are still a little bit up in the air. We're not entirely 100% sure on what to expect or, not necessarily what's going to happen. But we are facing a lot of questions from our clients in social care who are already concerned about increased inspections. In 2025, 71% of care providers had at least one minimum wage non-compliance failure. This has been covered by a webinar that we've run if you want to check that out. But the cost to the sector was over £38 million in arrears and penalties. This figure is set to go up in 2026. As the average cost of a national minimum wage breach is expected to exceed £50,000. What do you make of that?
That is absolutely a massive figure, like you've said. The other point is that's alongside increased HMLC enforcement. The Employment Right Act 2025 brings the introduction of the Adult Social Care Negotiating Body in 2026, with fair pay agreements following. These will set the legal minimum standard for pay and terms and conditions of employment in the social care sector.
Yeah, I think it's a difficult industry to be in. Another difficult industry to be in, unfortunately, with all of these regulation changes. But we are here to help and give you those preventative measures. Essentially, that's what we do. That's our bread and butter, is protecting businesses. So if you're unsure, reach out for that support. And with question 6, this is obviously quite a complex one with more difficult legislation to be rolled out to businesses. But somebody's asking, should I change my probation period to 6 months?
The changes that the Employment Rights Act 2025 brings in are the reduction of the length of service an employee needs from 2 years to 6 months. Now, if an employee has a 6-month probationary period, by the time that decision on probation is made, if they go into the notice, it's likely that they'll have already passed that. which means that they inherit the right to bring a claim for unfair dismissal. This is a question we regularly hear, and the best advice on it is to reduce the probationary period to 3 months initially, and then to, if required, to extend it by another 3 months, so they're still within the 6-month period. But again, the employer has to be really careful to make sure that the second probation meeting happens before the 6 months period. If the employment does last the 6 months, then it becomes a little bit harder for employers, because they then bear the burden of proof in a tribunal to prove the reason for dismissal is a fair reason. So it is best to update the policies and make sure that it's set out very clearly to employees.
Absolutely. And if you are, wanting to extend somebody's probation, you're risking that fine line of it becoming, qualifying for an unfair dismissal claim. You want to make sure that you've documented every one-to-one, you've got all of the evidence in place, you're setting smart targets for those reviews and making sure that if you are going to go past that 6-month mark for a probationary dismissal, that you've got the evidence to corroborate that decision, essentially.
Yeah, especially when you go to tribunal, it's your account versus their account. And it's well known that documentary evidence is the best evidence. Witnesses can forget things. Even, you might not remember what you had for breakfast yesterday, but when you've got it on the papers, you can put that in front of the judge, and the judge can see that the reason for the dismissal is actually the conduct, the capability, some other substantial reason. It's easier for the employer then to defend their position.
Absolutely. So question 7 is it true that I need a harassment policy?
It's really, really important to have a harassment policy. The changes now that are coming in are going to require employers to take all reasonable steps to avoid harassment. That includes third-party harassment. So if an employer is contracting with another company and one of their staff discriminate against your staff or harass against your staff, the employer will be held liable for it. The best way to tackle this is for the employer to, number one, have a contractual clause in their contracts which requires the other company to behave in an appropriate way, summarising it. But also they can look at doing business only with companies which themselves have a harassment policy, have really strict equality and diversity training. That is the best way that the employers can use to prevent sexual harassment. The other change that's coming in is the sexual harassment is actually now being added on as one of the grounds for whistleblowing. So even if an employee complains to an employer that someone has been sexually harassed, whether it's them or not, if there's any repercussion from that, they will have the right to complain that they've been put to a detriment. So it's really important for employers to have clear policies set out, what to do, how to react with it, and how to prevent it.
Definitely. I thought those are really helpful tips, actually. It's really interesting from your perspective, obviously, tribunal level, talking about those preventative steps. I think, be careful who you work with, who you're going to engage with on a business level. Don't just accept anyone. If you've got sort of tender requirements, things like that, make sure that you're doing business with good, honest businesses who are going to also protect your interests as well. The next one, what's the deal with fire and rehire these days?
So fire and rehire is going to become automatically unfair. Fire and rehire can basically be dismissing an employee and then re-employing them on different terms. So that can be different hours, different pay, different holiday entitlements. Employers need to have a reasonable reason to fire and rehire. They will have to say to the tribunal that the reason that they dismissed, it is a justifiable and fair reason. Failure to do so, they'll be having a lot of claims coming up against them in which claimants will succeed.
Absolutely. And the change that's coming in is that the only way a business can justify that decision to fire and rehire is that change was integral to the survival of the business, essentially. That's correct, isn't it?
Yes, and this change is coming in from January 2027, so there's still some time for employers to put these procedures in place, but make sure that the employer is informed and it is clear to everyone involved that this is a necessary need for the business.
Absolutely. So the next question is something that I get asked all day, every day, and I think the reason for that is because there's always so much clickbait around this topic online. A lot of governments will come into power and promise to ban 0-hour contracts. So the question is, can I still have 0-hour contracts?
0-hour contracts in essence will become contracts which have guaranteed hours, so the answer shortly is no. these type of contracts, they're mainly used in gig economy situations where you've got events, hospitality, them sort of situations. The changes that they're going to bring in are that the employees will tend to have a generalised guaranteed hour minimum. So even though they may currently be employed on a 0-hour contract, once the changes come in effect, the employer will have to agree a minimum number of hours with them. They'll also require employers to have procedures for shift cancellation. So if an employee is scheduled for work and the shift gets cancelled, the employer will still be liable to pay that amount. Now, whether they can recoup that from their client is a matter outside of the employment tribunal jurisdiction, but they will be liable for paying it. And there'll also be more predictable notice required for shifts as well.
I think it's going to be a really big and difficult change for, especially the care industry always springs to mind. You know, those who work in perhaps domiciliary care, your work and your hours are based solely around client need, and if that client need declines due to the passing of a client, and perhaps the care is funded by the council or those kind of situations, you know, where are businesses going to get the money from to accommodate the you know, these new regulations? I think it's a difficult time for businesses. It really, really is. But yes, obviously the changes to 0-hour contracts massively benefit employees, which is a positive thing. But I think there is, you know, still a detriment there to businesses, really, to again foot that bill. So with the next question, somebody's been told that they can't refuse a flexible working request. Why not?
Well, employers can still refuse flexible working requests, but they have to have a valid reason for doing so. Just to refuse it on a whim isn't a valid reason. They have to look at the business needs, they have to look at how much staff they have on site, how much work is coming in. And then if it's in the business needs for that staff not to be left to go off on flexible leave, the employer will need to justify that and state that to the employee that we need you, we can't give you flexible working at this time, but we may be able to revisit in the future. Employers also need to be really careful with flexible leave in the instances where someone's asking for flexible leave for paternity reasons or for carers reasons. They really need to make sure that they're adopting clear policies and procedures which are fair to everyone.
Absolutely, and flexible working policies are those kind of policies that just always seem to need an update, unfortunately. Obviously we can provide you with the most up-to-date version of that policy, and you can see what that looks like, but it's just one of those areas that is constantly evolving. But yes, it's becoming more difficult for business owners to justify declining a flexible working request. What can you do as a business owner to make sure that you're in a good position to decline that request? Document evidence, you know, make an evidence trail as to why you're able to make these decisions. You know, why can't you divide that work between other members of staff? Why don't you have the availability or the infrastructure as a business to accept that flexible working request? So yes, you can still refuse it, but you just need to be smart about it and make sure that you're using the correct legal reasons for doing so. And the final question that we've got here is, a lot of these changes won't come in until next year. Why do I need to worry about them now?
So the changes to the unfair dismissal, the actual 6-month qualifying period to bring a claim will start in January 2027, and that's retrospective. So if an employee starts with an employer 6 months earlier, by the time they get to January, if they are dismissed, they have a right to bring a claim. But also the time limit for bringing a claim is increasing. Where traditionally it was 3 months, they're now going to have 6 months. But that means the employee is going to have a longer period to think about whether they want to bring a claim. Now, traditionally what we've seen in tribunals is the longer a claim takes to bring in to be heard, the weaker the evidence is because it's not as reliable. It's definitely going to impact employers, this. The best thing that they can do is make sure, like you said earlier, document everything, make a clear audit trail of what's happening, why it's happening, how it's happening. That not only helps the employer build up the evidential file, but when it comes to witness statements and the evidence that they're going to give, they can paint their picture of their arguments, that this is the reason we had to reach the decision. It is a worrying change, but by tackling it head on, you can get on top of that change and take the lead.
Absolutely. Yeah. Thank you for your time, Yousaf. That was really interesting and really informative, I'm sure, for all business owners watching this. Thank you so much for your time, and thanks for being here.
No, thank you very much. It's been really nice coming on your podcast, and hope to see you again.
Thank you very much. This podcast forms part of a wider series on the Employment Rights Act 2025. Obviously, there is a lot to discuss. We have done many webcasts on the topic that you can find on www.brighthr.com/webinars. You can rewatch any of those sessions there, and there is a lot more to talk about, so we will keep it coming. But thank you all for your time, and thank you for attending.